Ninjani Molweni Afsheni Tobela Nda. Here we are with MRL2601 Entrepreneurial Law, and we will be answering this question for 2023 examination. Yeah, you must know about the entrepreneurial law. Number one that you must know is that this module is based on this module. It's based on the company law, which you're about to do soon. This is because the company law and MRL are interrelated, and I will show you why they are interrelated, and then we'll answer some of the questions that you can see that they are really interrelated. So you will need to know that you will be doing company law soon, so you must know MRL very much because it's the same thing. So let's come back. The other things that you need, it's a Company Act 71 of 2008, and the other things that you need in the examination will be this book, Companies and Other Business Structure, which is the 4th edition. This is the best book. You must have this book for the 4th edition, because this book is a newer than the book that you may be using. So I'm just showing you this material so that you won't say, hey, where did you get this? Where did you get this? So I'm telling you now where I did get this. So let's try to answer one question I want to show you. Since I've told you that company law and MRL is the same thing, they ask the same questions. Let's start here. Question 1 is a reference to the relevant legislation and case law. Explain the legal consequences of the recognition of the company's separate legal personality. So if you can come here, for example, you can see here another question is saying that name the different types of companies that are provided for in the Companies Act 71 of 2008. I'm just showing here that the legal personalities here, the type of companies are here in this book. So everything in this book is well, you can see that we have a legal personality limitation and liability, shareholders, legal personality of a company, a wrong to a company who's not a shareholder. We have incorporation and registration. Everything is here. So because we talk about legal personality will come here. So I'm just showing you some of the things that you must know. Now we talk about the legal personality is well documented. If we can see here, there's the cases and many cases that are based on the newer. So I will come back and answer this question. Let me just do this. Then when we talk about the types of the company, we have the types of the company, they are here. I was just showing you some overview about this book that you must use, because it has everything that you need to survive in the examination. So let's go to question now. I'm starting to let's go and start with some big questions rather than questions that are not so obvious. So question 3 said that Lisedi and Simpi were registered Funmex Pty Ltd. You must know that this is a private company. Pty Ltd is a private company, a company that sells office equipment. The MIO, which is, we call it Memorandum of Incorporation, indicated that the board of directors, consisting of Lisedi, Simpiwe, Carol, and Precious, can appoint a managing director who would be authorized to contract on the behalf of company. However, the board has never formally appointed a managing director. Nevertheless, Lisedi, with the full knowledge of the other director, has contracted with Office Supplies Ltd for the supply of office equipment too. So he contracted with a public company on two occasions. On the third occasion, that Lesedi contracted with Office Supplies Ltd. Fanimex denied liability for the payments for the equipment based on the fact that Lesedi was never appointed as the managing director. Upon being sued by Office, Fanimex opposed to the claim payment in terms of the agreement based on the fact that Lesedi was not authorized to contract on behalf of the company. So the person was not authorized he was not authorized to contract on the behalf of the company. Then number 3.1, explain with the relevant case law what office mean. It says that to explain with the reference to relevant case law what Office Supply Ltd will have to prove in order to rely on the doctrine of estoppel. Remember, the doctrine of estoppel is the doctrine of misinterpretation. If the company has been misrepresented, doctrine of estoppel is the doctrine of representation. So if somebody has been misrepresented, he must raise the doctrine of estoppel, right? This document is very, very important for you to survive in the examination. They said when it is found that the representative of the company did not have actually authority to represent the company in an agreement with a third party, the third party may, under certain circumstances, rely on the doctrine of estoppel to hold the company liable in terms of the agreement. Briefly state what a third party should allegedly and prove in order to hold the company liable to an agreement on the basis of doctrine of estoppel. They said that to answer this question, students had to note that a third party should allegedly and prove that the company intentionally and or negligently misrepresented the agent concerned as having the necessary authority to represent the company. Number 2, the misrepresentation should have been made by the company. And number 3, the third party was induced to deal with the agent by misrepresentation. The fourth one, the third party was prejudiced by the misrepresentation. And if you need more, you can check the online letter at unit 4, paragraph 4.6. So this is what you must prove. You must prove that the company has negligently or intentionally misrepresented, and then the misrepresentation was caused by the company. The third party was induced to deal with the agent by misrepresentation, and the third party was prejudiced by misrepresentation. So let's go to another question. Okay, we have answered question 3.1.1. Let's go to question 3.1.2. Assume that Lesedi was formally appointed as the managing director, but that instead of office equipment, Lesedi has brought a race car on behalf of Fanimex Ltd. Explain whether Fanimex will be successfully in denying liability for payment of the purchase price based on the fact that the race car has nothing to do with the company's business. When you have you purchase something that has nothing to do with the company, we call that ultra vires. You must know where to find information when you go to the examination. You do this by reading. So I told you that when you have contracted with something that is not part of the company, we call it ultra vires. So you must come here and just say ultra vires. They said the ultra vires doctrine is the rules pertaining the consequences of company acting outside of the scope of its power and competency. Then today we deal with the ultra vires. In terms of the common law, a contract is ultra vires. The company when the conclusion of its transaction is beyond its legal capacity. In other words, If a company's principal business is, for instance, catering, it will be outside the company's capacity to buy an expensive yacht on behalf of the company. Then what about the ultra-virus? Is it still operation? No. Ultra-virus is no longer in operation. Why? Because they said a company becomes a separate legal person upon incorporation, and it continues until it's been deregistered, provide that a company has all legal existence. Therefore, the contract remains valid and binding on the company and the other party to the contract, even if it is ultra-virus transaction. So, if you need to summarize, just here to summarize and summarize these cases, then you talk about this ultra-virus, and then you talk about the additional. However, the shareholders have the recourse, or they have the remedy in terms of section 26 of the company, which they can claim damage against the person who they fraudulently or caused them a damage. So now we know about this one. I won't be reading for you because you have a study guide. You can go and read for yourself. So this one you must apply a virus, and told them that according to section 19, the company the company will be liable for such a contract. However, they have a recourse. Michael is a shareholder. He believes that the board of directors is using company funds for its personal gain. He wants to bring an action on behalf of the company against the directors. Advise Michael briefly on the steps that must be taken to bring a derivative action. So we are talking about derivative action. So because the question is talking about the derivative action, I told you that you must have this book. Then you just come to this book, The Company's Law, 4th year, Other Business and Structure. What a nice book. We are going to the derivative, right? Talk about the derivative one. Very much important to have a. Then, of course, chapter 14 talks about the remedies. Of course, here I'm sure that you need to know about the remedy. Sorry. Yes, here we have the derivative action. It's in terms of one section 65. So here on the Companies Act, it means that we have to go to the section 165, which talks about the derivative action. See, you find things easier when you have the documents. When you have the full documents, just find things easier. We have not even made it to 165. 201. We are on. Well, let's see here. 166. It means that this is 165. It's big, 165. So here is section 165. It's called the derivative action on the Companies Act. You can see here the derivative action. They said that a person may save a demanding. Let's check here what in the summarized way. Derivative action. It was decided in the case of Fox versus Harbotley. In the case, two minority shareholders allegedly that the property of the company had been applied and wasted by the directors, and that various mortgages were given improperly over the company's property. The minority shareholders acting as the plaintiffs in this case asked that the guilty parties to be held accountable. The court dismissed, and then blah 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 blah. We have a derivative action, and then it's been explained. It's up to you to go and read about derivative action. I'm not going to read for you everything. So it's up to you to just go and read about this one and summarize some of the cases of the derivative action. So let's go to another question. How much is it one? Is this a question? Okay, this is the big scenario. This one of the Amos blah 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 blah. It's a big. However, there's this one. This the shareholder wants to institute legal action on behalf of Props Camp Ltd against the board of directors for breach of their duty to care, skill, and diligence. Amos as head of the business judgment rule, which apparently affects the director's liability. Explain to Amos what the business judgment rule entails. Also indicate whether the rule will protect Amos in these specific circumstances. So we need to know what is a business judgment rule, right? Then you can see here there's this beautiful document here. They say that discuss the business judgment test or rule with specific reference to the provision of section 74 of the Companies Act, blah 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 blah. In terms of section 76 subsection 4 of the Companies Act, the business judgment rule provides that a director will have satisfied the duty to act in the best interest of the company and the duty to act with a degree of care, skill, and diligence, provided that the three elements of the business judgment rule are present. They had to refer to those three elements, which are the director may rely on the performance and advice of employees, professional persons, and the board of committee. The effect of the business judgment rule is that a director will not be held liable for decisions that lead to undesirable results if the director is complied with the requirements of Section 76, subsection 4. It's support of the business judgment rule that it serves as motivation for capable person to accept the directorship, and that it encourages directors to engage safely in risk-taking activities. On arguments against the business judgment rule, they had to provide that it could result in accepting a standard of conduct that is below acceptance standards that ought to be required of directors. Moreover, the exact content of the business judgment rule is difficult to define and establish, and the difficulty in the codification thereof is evident in the various attempts undertaken even in the United States of America. Right? Then on this new book, it says that the business judgment rule entails that a director should not be held liable for business that lead to undesirable results where such decisions were made in good faith, with care and on an informed basis, and with the director believed were in the best interest of the company. The rule provides that a director can be excused from liability where the latter made a decision in circumstances based on adequate information and where a decision was arrived at in good faith and made in the interest of the company. This, the judgment rule represents a safe harbor. A director whose action or decision based upon a fide assessment. Those supporting the judgment rule, then there's a blah 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 blah. Then they're talking about some of the things that we have already read. Then they give some cases about judgment rules. Um, they say that they given the case. Then it's up to you to go and read that case and summarize it. So I've already given you what it's like with the books that you must have on your site in order for you to know. Question 4 is talking about what? Question 4 is talking about CC. Let's say that let's not answer it today. We'll answer it the other time. Let's check here. Okay. The 2.3, the director of Gangnam Tiles Ltd are uncertain as to whether the company must appoint a company secretary with reference to the Companies Act. Advise them whether Gangnam Ltd is required to appoint a company secretary. You must know that a company secretary is only mandatory to be appointed in the to be appointed in the public company and state-owned companies, and not in the. I'm trying to go to that place very fast. Is it section? Yes. Section 86. Section 86 stated very clear that a public company or a state-owned company are the one that must appoint a company secretary. So those others they can appoint, but involuntary. So in this question, you must tell them that only the state-owned company and the public company can appoint a company secretary. It's a must. It's a mandatory. However, since Ganam Tiles Pty Ltd is a private company, it is involuntary. They can appoint secretary on their own accord, right? Which other question? This one of a proxy. This one is a very simple question. Vela is a shareholder of Impala Ltd. The next annual meeting will be held 30 November. Unfortunately, at the time we will be overseas on a business trip. Vela would, however, still like to vote on some matters that will be discussed at the meeting. Advise him regarding the possibility of appointing a proxy to attend and vote on his behalf at the annual general meeting. Also indicate the validity of requirements for appointing the proxy. Right. So even here in this book that I've told you, there is a proxy here. Is dealing with the proxy. Proxies are everywhere, right? They're represented by proxy. I'll check. Sorry. I was at the proxy. Yeah. And I didn't choose the. So represented by proxy is here on this book. You just come and open a proxy. Is a person appointed by the shareholder according to the Companies Act. Then there's some cases there about the proxy. Everything about the proxy. Section 58 of the company provides that the shareholder of the company may at any time appoint any individual, including an individual who is not a shareholder of the company, as a proxy to participate in and speak and vote, blah 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 blah. Then they said yes, some cases that have been discussed there, which you can use in the court held that Section 58 provides that a shareholder may be appointed anytime of the companies. Then now we know about that. Then which question can we tackle now? We've already tackled many questions here, so I believe that we'll go to another question paper and just see what that question paper is like. Then we try to answer such a question paper. For now, let's say that we'll answer the question paper next time when we meet again in the MRL2601. Thank you guys for watching. Don't forget, you must have companies, you must have this book on your side when you enter into the examination in order to be everything to be good. You need the companies, you need the company, you need the Companies Act. Then you will need this secret document that will help you if you are you forgot or you can't find things on the book. It's a very good document. So thanks guys for watching. I'll make another video of MRL2601. This is the very easiest module of them all. Have a good day.